Parliament's power to amend the fundamental rights was challenged in year 1951. After independence, several laws regarding land agrarian reforms were passed in several states with the aim of reforming land ownership and tenancy. This was keeping into consideration the ruling Congress electoral promises regarding the implementation of socialistic goals enshrined in Article 39B and Article 39C of the Constitution. These articles provide for the equitable distribution of resources of production among all citizens and prevention of concentration of wealth in the hands of few. Landowners which were adversely affected by such laws challenged the same, and the courts declared these laws as unconstitutional. Parliament, by reacting to the decisions of the courts, placed these laws in the 9th schedule of Constitution and thus made them immune from judicial review through 1st and 4th constitutional amendment. The question whether fundamental rights can be amended under Article 368 came for consideration before the Supreme Court in Sankari Prasad Deo versus Union of India, 1952. In this case, the validity of the Constitution, First Amendment Act 1951, which curtailed the right to property guaranteed by Article 31, was challenged. The argument against the validity of the First Amendment was that Article 13 of Constitution prohibits enactment of a law infringing or abrogating the fundamental rights, and the word law in Article 13 would include any law, even a law amending the Constitution, and therefore the validity of such a law could be judged and scrutinized with reference to the fundamental rights which it could not infringe. The court rejected the contention and limited the scope of Article 13 by ruling that the word law in Article 13 would not include a constitutional amendment passed under Article 368. The court observed, and I quote, "We are of the opinion that in the context of Article 13, law must be taken to mean rules and regulations made in the exercise of ordinary legislative power and not amendment made in the exercise of constituent power under Article 368 of the Constitution." Adopting the literal interpretation of the Constitution, the Supreme Court upheld the validity of the First Amendment. The court disagreed with the view that the fundamental rights are inviolable and beyond the reach of the process of constitutional amendment. The court thus held that Parliament could, by following the procedure laid down in Article 368, amend any provision of Constitution, including fundamental rights. Therefore, in absence of any clear and express limitation to the contrary, the plenary power of Parliament cannot be restricted. The same question was again raised in Sajjan Singh versus State of Rajasthan, 1965, wherein the validity of the Constitution, 17th Amendment Act 1964, was called in question. The impugned amendment again adversely affected the right to property. By this amendment, a number of statutes affecting property rights were placed in the 9th schedule and were thus immunized from court review. In the instant case, the court was called upon to decide whether the amendment of the Constitution insofar as it purported to take away or abridge the fundamental rights was within the prohibition of Article 13, Clause 2. Whether Articles 13A and 13B, as amended by the 16th Amendment, sought to make changes to Articles 132, 136, and 226, or in any of the lists in the 7th schedule of the Constitution, so that the conditions prescribed in the proviso to Article 368 had to be satisfied. One of the arguments was that the amendment in question reduced the area of judicial review, as under the 9th schedule, many statutes have been immunized from attack before a court. It thus affected Article 226 and therefore could be made only by following the procedure prescribed in Article 368 for amending the entrenched provisions, that is, the concurrence of at least half of the states ought to have been secured for the amendment to be validity effectuated. The Supreme Court again rejected the argument by a majority of 3 to 2. The majority ruled that the pith and substance of the amendment was only to amend the fundamental right so as to help the state legislatures in effectuating the policy of the agrarian reform. If it affected Article 226 in an insignificant manner, that was only incidental. It was an indirect effect of the 17th Amendment, and it did not amount to an amendment of Article 226. The impugned act did not change Article 226 in any way. The court laid down that Article 13, Clause 2 did not affect the amendments of Constitution made in exercise of powers conferred on Parliament under Article 368. The court held that the constituent power conferred by Article 368 on the Parliament included even the power to take away fundamental rights under Part 3 of the Constitution.